we're happy to move along the case. They have had their chance to raise their objections. They raised them, the court ruled. That is due process. And so we hope that in January we will be able to conduct the proceedings. Well, what we do is the formal proceedings of putting in the request so that the learned magistrate can examine the evidence in the request and rule on the sufficiency of the evidence in the request. The ruling touched on all the issues and indeed, with respect to the judge, gave a very good summary of the law and guidance to any magistrate as to how to approach this issue.
We believe that the court improperly exercised its discretion this morning when it found that the application should not be referred to the High Court. We believe that we would have established clearly the basis for it, the inconsistencies in the decisions, and clear unconstitutionality in relation to these provisions which were amended in 2009. We are entitled to approach the High Court itself as part of the procedural process set out in the Constitution. We ought not to have gone to the High Court initially. That is why we made the initial application, so we could get past this prosecutorial and stage in the process. We intend to go to the High Court. It is our right, it is the client's right to go to the High Court, and we will be going there as part of this process. The law does not refer to it as an appeal, but it is a sort of leave process where what happens before the court under Article 153.3, you come to get a referral and approval, a preliminary sort of application, where the court functions as a sort of gatekeeper. The court has refused leave, let me put it that way, and thereafter you make the substantive application to the court itself.